Good afternoon, everybody, and welcome to today's webinar, episode 10 of Association Continuity in a COVID World. My name is Craig Vaughn. I'm the president of Castle. For those of you who don't know Castle, we specialize in the management of condominiums and HOAs in Florida. We partner with approximately 300 associations through 300 associations through 7 offices with about 1,750 teammates. Welcome back to those who are joining us, and welcome to our new webinar participants. We're excited to have you this afternoon. As a reminder, Marinette said you can chat in your questions through the webinar, and I'll try and work those into the discussion. We'll have some polling, as we always do, which is a feature we like, so we'll have some questions for you. We'll get back to that shortly. But when you see the questions pop up, we'd like you to answer as soon as you can. So that we can get the answers right back to you quickly. So guys, before I get you to introduce yourself, let's start with the first question, Marinette, if you can. Let's find out who's in the audience today. So it's a two-part. Question number one, what type of community do you live in? And question number two, are you in a 55 or better community? So while you're answering that, I wanted to welcome back Michael and Jeff. Before I have them introduce themselves and the firm, I just want to remind everybody that they are here to provide their opinion on the items that we'll be discussing, not to give legal advice to your community. For specific legal advice, please reach out to your counsel. Jeff, welcome back this afternoon. A few quick words about the firm.
Sure. We are a law firm specializing in representation of Florida's community associations, developers occasionally, and sometimes owner claims as well. We're comprised of 19 lawyers, 8 of whom are board certified experts in the field of condominium and planned development law. We have offices near you, Craig, in Broward County, Palm Beach County, Hillsborough County, as well as by appointment in Miami-Dade. We publish 2 publications, Legal Morsels, written by my partner, Robert Kay, and I publish Rembaum's Association Roundup, the community association that you can use, which is the number of articles numbering over 250, focus on new court cases, legislation, other matters affecting those who live, operate, and manage community associations. Robert Kay hosts a monthly community association radio show, Ask the Experts. You can catch Robert on the first Thursday of every month from 6 to 7 on channel 1470 AM. Peter Mullengarden co-hosts a weekly radio show, Condo Solutions, every Monday from 9 to 10 in the morning on channel 1450 AM. We provide numerous webinars on a whole variety of subjects, and we are getting really well known for providing one of the most informative and energetic board member certification seminars.
Great.
And that's just a little bit about us.
Talk about board member certifications. You're still struggling with quick, 10 episodes in, but I think we'll get you there eventually. Michael,
we have a lot going on. That was
we
quick.
do, and he did an excellent overview. I will add just a couple of items. Jeff did leave me a couple of them. One, I want to say with the radio shows, I also want to point out that kbrlegal.com, our website, you can actually stream watch them. They're streaming. Forgive my really sounding old when I'm saying the wrong words here. But you could stream those shows. I believe Peter's for sure, Robert's. I know Robert's for sure, but I think Peter's as well. So stream them off the kbrlegal.com. I also want to point out that we are very active in legislation. Several of us are active in the Florida Bar on the condominium subcommittee. Sean Brown out of Tampa, Allison Hertz, and our Palm Beach Gardens office in particular serve on committees, and then several of us who are involved. And I actually am the current chair and have been for the last 3 years, 2.5 years, I should say, for the Florida Legislative Alliance, which is the legislative arm of Community Associations Institute. We'll briefly be talking later about some of that legal stuff, but I wanted to just point out that, yeah, as Jeff pointed out, we are full service and we bring a lot to the table, and if we can help your communities, let us know. But with that, let's get started in sharing our info.
Great,
and before we jump back in, Craig, maybe we should focus more heavily in the future on the 2021 legislation, something for us to talk about.
That's a great idea, and I'm going to get a radio show. Those are the two
there you go.
already taken out of this meeting.
Why don't we invite you to a radio show? We should come on the radio with us one day.
Absolutely. Guys, I thought, we would continue to build on our theme from last session, which is kind of running the business of the association in the current environment. So with that in mind, I just wanted to run through topics we thought we will cover today. Current county order update. We're talking about emergency powers that are expiring quickly, potentially. So we want to talk a little bit about that. want to talk about budgets. We started it last week or 2 weeks ago, the discussion on budgets. Rules regarding contractors. We're getting a bunch of questions, continual questions around contractors. And then we'll do a little legislative check-in. So that's kind of what I had on the list for today. But before we get there, Marinez, will you post the results of our poll and see who we have in the audience today?
Mm-hmm.
So pretty consistent, guys. 60-40 condos, HOAs. For the HOAs, 52 of 100, so half are 55 and better communities. So a pretty consistent, I'd say pretty consistent group. Thank you, Marinez, if you can take that down. So guys, first thing up, current county order. I know on the county front, there are a couple of new orders. Michael, will you start with Broward, and then Jeff will move on to what's going on in Palm Beach.
Sure. Hello, everybody. Again, it's good to be back. With regard to the Broward County, on last Friday, they did issue Broward County Emergency Order 20-24, and it really had two points to it. The first point had to do with the short-term vacation rental reopening plan. And what it did simply was the portion that required vacation rentals in Broward County to be actively managed by on-site owners or on-site management or security with staffing or security personnel for 24 hours. That was put in place as of July 20th. It was through August 20th. They didn't extend it. They struck that out. So that 24-hour on-site management is no longer a requirement. But you still are required to provide contact information to the county and to allow them to know who's on your property. And this is all about contact tracing. The second part of it is that they extended it for business operations, in particular the restaurants. That they now on-premises dining is open till 11 p.m. in Broward instead of 10 p.m. The curfew is now 11 p.m. to 5 a.m. It also did allow bars, pubs, and breweries, as well as billiard halls, clubs, cocktail lounges, to open so long as their establishments derive less than 50% of gross revenue from alcoholic beverages. If they were derived more than 50% from alcoholic beverages, they are to remain closed. And that's the whole Broward County order. So it's really the short-term rental, removal of the 24-hour monitoring, and extending in-premises dining till 11 p.m.
Excellent. Jeff?
Well, we have a big push in Palm Beach County to move into phase 2, which means additional business openings, indoor restaurants to 50% capacity, groups of up to 50 people will be able to meet. It hasn't happened yet, but stay tuned. It'll probably in the next week or two, we'll probably move into phase 2. Civil and criminal penalties exist for not wearing your face mask, which is required until September 22nd, when you cannot socially distance. You need to be wearing your face coverings. There is the vacation and short-term rental ban prohibition is lifted, and we know that we're coming to an end. We don't know if it's going to be extended on the foreclosure and the eviction moratorium for non-payment of rent toward the end of this month, August. You'll have 3 days to pay, and if not, then the courts are going to probably get very quickly overloaded. In addition, I read an article, this was fascinating, in some of the HUD mortgages, this isn't Palm Beach County, this is everywhere, but half of this country has non-judicial foreclosure process. Florida, in order to foreclose, you have to get in front of a court. Except some mortgages, and I'm sure this will be a surprise to some people, some mortgages provide the lender the right for non-judicial foreclosure even in the state of Florida, meaning you could get your notices via U.S. mail and find yourself, if you haven't paid your mortgage in some time, divested from your property. I've only heard of it being done one time so far. The article was either the Palm Beach Post or Daily Business Review in the last several days. So more on that as the situation develops.
Crazy. Guys, we do have a question. I know the state is, other than South Florida, is in phase 2 of the kind of opening, if you will, the reopening. There is a question from one of our participants that, if we go to phase 2, sorry, we're not in phase 2, the rest of the state is. If we go to phase 2, does that have ramifications on opening our clubhouse facilities? Or
the orders have all expressed that municipalities can be stricter and associations can also be stricter. So it does not mandate that the association open up amenities or modify how they're opening amenities, that in and of itself. that remains something that is within the purview of the reasonable business judgment of the board, along with and consulting with their management team and their legal experts. Craig, I just want to say one other thing, and Jeff was pointing out, just for Lauren, Jeff was pointing out Palm Beach with regard to the order on mask requirements. The mask order in Broward has not changed. It is still in place. Masks are still required in Miami-Dade, Broward, Palm Beach, as they were before.
Okay, guys, let's jump to emergency powers. 8 weeks ago, when the governor extended the executive order and declaration that we were in the state of emergency, it was all kind of seemed good. It seemed a long way off before we had to deal with it again. And here we are 10 days away from the emergency order expiring again. So let me get your gut feel. Do you think that it gets extended, guys?
I do. I think we're going to see one more extension, minimally. And I don't know what's going to happen after that. And I haven't heard anything. I haven't read anything. I want to make that very clear. It's just a gut feeling, 32 black and you. So.
I agree. I would agree 100% with Jeff. Again, I have not read anything, but let's remember also, we hadn't read or heard anything prior to the last extension, and it came at the 11th or 12th hour.
Right.
I think what we keep seeing, everybody sees the reports on the positivity rates and that kind of thing, and those numbers are still up. They're still closer to almost up double digits, at least in South Florida. And they are throughout the state. There are still cases. So I would be very surprised if Governor DeSantis did not extend the emergency order for at least another month.
And guys, if he doesn't, are there any, what should a board do now to prepare? Is there anything they should be doing? I think, Jeff, you've given us some guidance in past webinars about, it isn't a drop dead date, everything changes. Is there anything
right.
you doing now?
I think it really is going to depend on what's happening in each community. For example, one community, and they could be miles apart from each other, might experience a micro breakout in their building of COVID-19, even though we're in a phase 2 situation. And that particular association is going to be taking different precautions and have different rules than a sister association down the street that isn't experiencing that kind of uptick, if you will, in COVID. But certainly governing documents should be looked at right now. To provide for certain powers and protections and an ability to do everything from the electronic voting and so many other things, getting members to opt into official communications through email. And Michael, what do you think?
I mean, again, I just piggybacking off of that. What I think, to me, we've talked about this. Associations are sort of like a mini government, if you will, and you have the different people. And talking not just one association, I'm talking multiple associations. If you look at the way our country is going, some states handle it one way, some states are handling it another way, and for some might be it's working, some it's not. When it comes to your association, you have to do what's best for your community. If the emergency powers are no longer in place, there are still, I think, the biggest point I want to reiterate is you need to get with your council to make sure that what you're doing is best protects the association, the board, your management team, and your residents. And in that regard, I believe you certainly be able to retain certain requirements, certain closures, limited openings, things of that nature. But on a specific basis, you're going to have to address these case by case, and we're dealing with it now. I mean, Jeff and I both are dealing with this now. Where communities are coming to us and asking us, hey, we want to start reopening, but we're not sure. Some are pressuring us to open, others are pressuring us not to open. And there's no panacea here. We're all, again, we've said this going back to April when we started. This remains a case of first impression for everybody. Right. And we're all working our way through it, and hopefully, cooperatively.
Jeff, I just want to touch on something you said about the e-voting. Does that have to be in your declaration, or doesn't the statute provide it? Okay, you don't need
the statute provides for that. Correct.
But there are requirements, Craig, that have to be undertaken. Boards have to do but they have to call a board meeting with a 14-day notice and adopt a resolution that's going to allow for electronic voting and set forth specific requirements, which get with your attorney and go through those. Make sure your T's are crossed and I's are dotted.
Yep. You have to work through the attorney when you're doing this.
Yeah.
We're getting a ton.
And you have to vet. So there's some very good companies out there who do electronic voting, have done it for years and years and years, and they follow Florida statutes. So that's a part of the vetting process for the boards and their management team.
Very much so. And Craig, you asked, is there anything a board should do now to prepare itself in the event the order isn't extended? And I keep thinking about it, a great bottle of red wine or scotch.
I would, guys, we're getting lots at Castle, lots of questions about the Zoom meetings, and again, Zoom has done a good. Every virtual meeting is now called a Zoom meeting, whether it's Zoom meeting or not. But
right,
platform. So we're working with that, and maybe we revisit that again in over the next month, because it looks like with this continuing on, that's going to be even a bigger push, I think.
I'd like to see, and I've started working on a set of procedures for certain association clients of ours to use Zoom and to have in advance the rules of the road, if you will, for the meeting, so that the members will know when they're going to have their opportunity to speak during the Zoom meeting and how that's going to occur, and even how they can get themselves thrown out of the Zoom meeting by not respecting the rules.
Mm-hmm. Right.
And I think it's important to set those ground rules.
I agree. And again, I think, hopefully, in the future, we'll have one of these webinars, Craig, and we're doing it because it's just a good format for a lot of people to get involved. And we're talking about, remember when we were doing COVID, it's in the past. But that said, I think that I think these types of, we'll call it Zoom or those types of meetings are helpful. They allow for a lot of people to join. And I think everybody, or at least those who are using it, are starting to become a little bit more proficient, and we might even be able to go back to Zoom and suggest things that will help our communities function better using their platforms.
Yeah, in fact, we're doing that at Castle, where you kind of have our series of best practices. This is how you do it. To your point, Jeff, raise your hand, do this, have a panel. It's very exciting, actually. It's kind of neat stuff. So
kind of fun. I love it.
Yeah,
I do too.
And it's less expensive for the associations as well when they need us at the meeting. We're there instantly. There's no travel time involved. It's just wonderful. It's great for everybody.
Very cool. Very cool. Okay, guys, I want to move on to budgets. Budget season is here. There's certainly some considerations for your 2021 budget related to kind of COVID and the environment we're in. I will remind everyone that a couple of weeks ago, when we did our last webinar, we had Andrea Northrup from the Insurance Office of America join us. And she shook us to the core, I'd say, with her update on the insurance market and what we can expect at renewal time. Rate increases between 20 and 40% for all policies, if you can get them in some cases, even before you consider, the fact that your values may have increased as a result of your insurance appraisal. Wasn't a pretty picture. We did ask our listeners last week if they had consulted their insurance professional since the pandemic started. Ness, I want to ask that question again. After listening to her, we recommended you reach out to your agent, get a feel for what might be going on out there. So let's see if our participants heeded our advice and talked to their insurance agent. Last session when we did this, about 68% had talked to their agent broker.
It should be 100.
Should be 100.
It's not fair that we can't participate, because I'm on the board of my HOA, and because of Andrea's conversation and our conversation last week, even my board, we have now set up a meeting with our insurance agent to discuss things. So I vote too.
We'll wait for the poll results to come in. It's looking the same, but it is amazing. In fact, I was at a meeting yesterday, and they got the board had got their insurance, an HOA, they had got their policy renewal for July 1, and it was up 69%.
Wow.
An absurd amount of money. So we'll see that. In fact, let's close that poll and see where we are. Wow. Good. You are the 34%. Get busy. Yeah, exactly. That is actually less than last time. So I will, maybe we have a bunch of new webinar participants, but I would say to everybody as a warning, this is going to be a big number, especially if you're in a condo on the beach. If you're in the throes of your budget now, highly recommend you get.
And Craig, you're right on point. And it is quote unquote budget season for most. So this is when you want to do that, because the last thing you want is to actually put a budget in place where you've underfunded your insurance by 20 to 40% or more, and then you're surprising everybody in 2021.
Yeah. Because fair enough, good stuff. So I think that's hopefully a takeaway for our group here. lots of things going on. We've talked about COVID expenses, how those are affecting the budget, additional cleaning costs, monitoring costs for the pools. By the way, did I hear you say, Broward, you're no longer required to monitor the pool?
You did not hear us say that.
You're not, so you still have to monitor?
The Broward order on the pools has not changed to my knowledge.
Okay, sorry.
It remains exactly what, either removing the furniture or continuing to monitor, and you're certainly continuing to clean if you're opening it at all.
And Jeff, same in Palm Beach, right? Continuing.
As far as I know, nothing has changed, right?
Yeah. So guys, so those costs, weren't budgeted in 2020, and I guess, there will be costs likely in 2021 associated with the, COVID coverage, things like that. So Ness, I want to ask our webinar participants, one, has COVID caused you to be over budget or under budget in 2020? And part two of that question is your association planning on adding a COVID-19 line item in your budget in 2021? And guys, will our webinar participants answer that question? Is it reasonable to include that line item in your operating budget, Michael?
In my opinion, it absolutely is. Again, operating expenses are expenses you anticipate having. Well, the bottom line is these are expenses you now need to anticipate you might need to have, certainly going into 2021. So to me, it's very reasonable. And again, one of the issues that has come up we're talking specifically like pools, in particular, opening of pools and the monitoring of pools. If the community is in favor of being able to open the pools on a more regular basis, then one of the considerations might have been a line item in to have a monitor, whatever that terminology is. But these are and that's supportable, because if you're required to monitor your pool, then that is a reasonable operating expense to anticipate for 2021.
Yeah, it's going to be interesting because, we still get the questions around, shouldn't my expenses go down because my pool hasn't been open? And now we're saying, actually, they're going to go up likely. Right. And so, that vocal minority who's looking for the credit is not going to be happy. Jeff, I see you're nodding your head.
Yeah, well, I do have a comment, but I was nodding my head in agreement to you. HOAs have no problem, I think, putting in the COVID-19 expense line item into their budget. But I'm wondering, as we are having this conversation, whether a cantankerous condominium owner, not that any condominium association has one of those types of owners, but someone who's upset that line item is in the budget. Now, condominiums are creatures of statute. They only exist because of Chapter 718. Well, what is supposed to be in the budget is described within Chapter 718. Perhaps there's a catch-all in the condominium declaration itself that would allow for that additional line item. But I think it's important we take a look at Chapter 718 and we take a look at the condominium association's governing documents for the authority to add that type of line item, just to prepare if you have a community where you have, people nipping at your heels all the time.
Right.
Yeah, that's a good point. I would say that you have, as far as I've seen, and Craig, you can certainly confirm this, there's a line item for maintenance related line item. So whether you were calling it, whether you were putting it as, if you didn't want to put it as a separate line item, you would obviously increase your maintenance line item, and you certainly have the authority in your documents in the statute for, most should have health, safety, welfare, but certainly the responsibility to maintain. And if
so that is part of more than one way to.
Yeah. So there's always, if not a specific line item for that, someone's questioning, why is our maintenance line item gone up? Well, it's because we have additional maintenance expenses, in particular due to COVID.
I think
right. Let's talk about this again with Nicole next week as well from Haverford.
2 weeks.
2 weeks.
Yeah, Mike, I think it's a good point in that you should be anticipating the expense. What line item you budgeted is kind of the result, not the process of incorporating those costs into the budget. So let's see, Marinez, if you could post the answers to our questions there. Has COVID-19 caused you to be over or under budget? More over than under, some no change. Interesting.
Most no change.
Most no change, yeah. Is your association planning on adding a COVID-19 line item or cost in your budget?
Wow, 50-50. That's interesting.
Exactly 50-50.
Yeah.
So,
although, you know what? What this tells me also is, like, again, it goes back to my point earlier where it's community by community. I mean, a lot of these, I'm not suggesting for those of you listening that the 90% saying, or 90 saying yes versus 90 saying no, or whatever the numbers were, that some people are budgeting at a certain level and other people might be budgeting at a different level, and they don't need to either increase or decrease their budget accordingly.
Right.
But it is interesting to see it was 50-50 right there.
It was. Guys, the other thing about the budgets I think we have to consider are two things. One, your vendors are all dealing with increased costs as well. Their insurance is going up. They're dealing with some of these other costs of, following CDC guidelines, all of those types of things. So, if you don't have those contracts locked down, you could see increases in those contracts. The other big one we talk about all the time is delinquencies and what's going on there. And, likely you're going to have increased delinquencies. I think people have weathered the storm, and we haven't seen a lot of increases in our market, but in our clients, but it's only can go so long, right? You only have so much savings to spend when you're not working or things like that. Are you guys seeing any increase in collection?
Not quite yet.
There's been an uptick.
I think we're
not
preparing
significant,
for
though.
it for sure. And I think when we're talking about budgeting, that associations need to also perhaps think about their legal expenses for next year, because if in fact there's going to be additional foreclosures in the community, and if they're association related, or if there's a lot of lender action in there, there's going to be more complaints that need answering and looking at, and there's just going to be additional legal expenses if there's tremendous amounts of foreclosures. And I hope there aren't, but be prepared for it.
Right. And I think that at least what we've seen, and we've worked with our communities and our boards, and Craig, you guys know this too, is encouraging boards to work with their membership in a way that, listen, the associations have to function, and we've talked about this before. Unlike some of their lenders, the associations have one source of income primarily, and that's the owners paying in. So there's been a lot of encouragement for people to, if you can't pay in full for whatever reason, to at least work something out.
Right.
And I think that's helped keep, at least that's been our philosophy, and work in our communities have been open to it. And like you guys, Craig, you guys have well. And I think that's helped a lot of communities to kind of keep things somewhat level. But there has definitely been a little bit of an uptick. And there's definitely been questions I can tell you from certain clients saying, listen, we've been patient enough. At what point should we be moving? And that's troubling.
We've been advocating on these webinars and to our clients, the collection as usual. You don't have to foreclose on anybody, but you got to get ready if you have to step up the game at some point in time. You're running the business of the association, right? You have an obligation to do that. But also, we are seeing the kinder side, which is go make a payment plan. Like, go figure it out.
And let's go into that just for a second. The payment plan. Associations should be liberal right now with everything that's going on, so long as they can continue to function before they take that last step of taking someone's home away for failure to pay assessments. But if someone's working hard and they're trying to catch up, entering into that compromise settlement where they're catching up over time with a hook on the back end, that if they become X number of days or X number of months delinquent again, that they automatically agree to the association assessment foreclosure in exchange for giving them that year or 6 months, whatever it is, to catch up on their delinquency, will make the expense far less on the association, because it won't be the foreclosure won't be challengeable at that point. So you can consult with the association's lawyer for that form of document that can be provided, where the owner will voluntarily agree if they go delinquent, agree to the foreclosure if they go tremendously delinquent and don't honor their deal.
I think that's a great point. And, we do keep sending our listeners back to their attorney, but it is an interesting time, and you want to I agree.
Well, and again, and Craig, you make just about this is, and I hope people recognize this isn't self-serving anyway, because we don't know who your attorney is. The point is, guys, you're running your businesses, and you need good guidance. You have your business experts, your management team, you have your insurance agents. We've been pushing you to. We're bringing Nicole on in a couple of weeks, to talk about your financial experts, and obviously as your legal experts. These are that you do want to contact your legal experts and make sure you're doing things, and do not put the burden on your management team to give you that legal advice. That is unfair.
Yeah, and not allowed. While your property manager will love to practice law, they're not allowed. So they can't give you that guidance. But
and don't tempt them.
Don't tempt them. Yeah, it is very important. I think on the collection side, Jeff, your comment is just get a form that is approved. You don't have to get it approved every time. Just get it approved. So you're not sending an email, it's okay, pay over 90 days. Like that.
Correct. You want everything documented correctly. Right. And under some certain circumstances, you want a there are several types of these workout agreements that we can provide, and you can use them appropriately.
And it depends on where they're at. And Craig, to your point, you do need business as usual, which means if people aren't paying and not responding, you are sending that first statutory letter. You're letting people know, listen, you need to communicate, or we're going to go to the lawyer. Once you go to the lawyer, there are fees involved. And then we're required to send a statutory letter that says, hey, we're going to lien you if you don't work something out. And then if it goes to the lien stage, it's at that point, to Jeff's point, that's where I said, listen, nobody wants to foreclose. We got to work this out. So rather than going through, well, it's a compromise. Rather than going through that expense, we'll work out a payment plan. You'll stick to it. If you don't, then you're agreeing to the foreclosure. So it depends on where they're at. And hopefully if you have to those on the board members on the webinar, communicating to your membership to encourage them to communicate with you before the lawyers have to get involved. It makes things much easier and smoother for all sides.
Absolutely. So guys, next week, in 2 weeks, we do have Nicole Johnson. Nicole is a recognized expert in the community association world relative to accounting. She's a CPA. Works for Hafer and Company, so we're going to have her on.
She is an accountant, but I do have to qualify. She is not a CPA.
Her firm,
but she is incredibly well qualified. She is an expert, and her firm has CPAs.
Yes, exactly. So she'll be on, and we'll have a bunch of questions for her around budgets, I'm sure, and other things. Mm-hmm. Let's move on to rules regarding contractors. We continue to get these questions. A couple of sessions ago, we asked our communities if they were allowing contractors to work in their buildings, whether or not they'd adopted additional rules. At that time, 88% of those polled were allowing contractors. Interestingly, 89% were allowing realtors. But I want to check in on this issue again. So Nez, will you post poll question number 4? This is really, we're looking for the condo and co-ops to answer here. In HOAs, most HOAs of now are allowing contractors to work in individual homes and realtors to show units again. But for for condos, let's see, who's allowing contractors and if they're doing any additional procedures. So Jeff, I know we spoke earlier this week. You were deep into drafting rules for one of your clients relative to contractor work in units. What are those rules?
Well, they're very interesting. They are still a work in progress. We like to work in conjunction with our client. They had some things that were important to them for what I'm about to share, and then we added some things that we thought were important as well. So just generally speaking, if the COVID levels in the condominium association are above a particular percentage, in this case 5, that's the threshold, then all work is going to be stopped. Nothing else is going to continue with the contractors coming in the building. So that is a prerequisite. Also, in this building of approximately 200 units, only 5 remodels can be taking place at any one time. The contractors have to agree in writing and sign that they've read all the rules we're talking about now and are going to continue talking about, and that they agree that they understand that they're responsible for the health and safety and welfare of their client as well as the other occupants of the building. The owner signs the agreement that they understand they're responsible for the acts of their contractor. The contractor cannot have access to the common elements except as needed to get to the unit. In other words, the restroom and the lobby. Hey, can I use that? No, you can't. They would have to either take care of their business before they come or wait till they get up to their client's unit, but you need to stay out of the common areas completely except to and from the unit. If you need an elevator, it needs to be reserved. You will submit yourself to screening on the way in every day for temperature as well as blood oxygen level. Insurance is obviously a requirement for the contractors, security deposits, as well as the unit owner indemnification for the acts of the contractor themselves. And that's just a brief purview of where we're going with these rules. But again, it's important that both the owner and the contractor acknowledge and execute their understanding of these rules.
So you do have a document signed by the owner indemnifying the association?
Understanding that if their contractor it's already in the documents themselves, Craig. I've never seen a declaration for a condominium that said the owner was not responsible for their guests, for their invitees, which the contractor is. But this is just another condition, if you will, putting it really out there that you need to take these COVID precautions seriously. If anyone gets sick because you acted negligently, the contractor in any way, then the owner could have liability. It's just trying to heighten everybody's awareness and seriousness of the situation.
Right. Mike, anything to add?
No, I think that's in line with what Jeff and I've talked about. They're comprehensive, but again, and to Jeff's point, it is going to be, I think it's a good overview, but certain clients are going to have more specific requirements than others. It's Craig, it was interesting you asked about that indemnification document, because that was what I was honing in on myself. And I think having the contractor required to sign off and defending, indemnifying the association, having the owner sign off on that. I don't want anybody to, again, talk to your own attorney too, but I'm not saying it's a panacea of protection, but it's something that it offers at least another level of, because if someone's bringing legal action claiming they caught COVID because this person was allowed to bring their contractor in, that's along the lines of, that's the legislative reform I've been working on with that reset organization that with the task force for the state. So that's a whole nother story.
Actually, what about, can we charge the contractors to come in? We have extra procedures, we're cleaning.
Well, we're not, that would be the owner's responsibility, I think, more so than the contractor. And even if you put it on the contractor, which would be interesting, the contractor's just going to get it from the owner anyway. So, but we need to go back to the declaration and the rules governing the association to make sure proper authority is there for the adoption of these types of items as well.
100%. Good point.
And then those rules being adopted, of course, adopted at a properly constituted meeting of the board before they can.
Right. And how many days notice required for this type of rule? We're talking about what someone does in their unit. So we're talking about a 14-day notice requirement to the entire community and posted.
Great. Well, that's good stuff. Okay. Ness, let's see what our listeners are doing. So almost everybody now allowing contractors, which is what exactly consistent with we're seeing boots on the ground. And then if you're allowing contractors to work in your building, have you adopted any additional rules? So we have temperature checks, some, not very many. Mask or gloves, lots. Limit on the number of visitors, some. Jeff, you have that.
Yeah.
Limit of hours, I think that's consistent. Can you just move that? What's the last one? Let's look at that. Signing a hold harmless agreement.
Very
6%.
few.
Wow.
Very few.
You know what we didn't talk about is the type of mask that may be required. As we're sitting here talking about this, I think I want to add that to these rules we're preparing right now. I don't want a thin little bandana around the contractor. I want something with some protection. I don't know that it needs to go all the way to the N95, but maybe the 2.5 micron at a minimum.
Yeah.
Might be a wise thing to do.
I'm surprised with the hold harmless stuff here. So that maybe is something for our audience to take away. And again, it's a standard form, right?
Right. Well, yeah.
I
got to be honest,
Craig,
when
I'm done with it.
I'm surprised that second line item isn't 105 out of 105.
Yeah. Yeah.
That maybe they don't require gloves, but certainly masks.
Yeah, because it's required by the orders. So interesting. Okay, last topic before we get to some questions, maybe guys, is the legislative check-in. And so, on the legal front, July 1 is usually the date when any new legislation comes into being. There is some new legislation affecting our association. So, Michael, I know you've got this well rehearsed. Can you?
No.
Michael's favorite topic, though.
We're still waiting.
Mike, I'm introducing you for this. Michael is the chairman of the CAI Legislative Committee. He goes up to Tallahassee. He lobbies. He's directly involved in getting community association legislation passed in a huge way, as is one of our partners in the Tampa office, Sean Brown, as is one of our other attorneys, Allison. But Mike is up there in a leadership position. So anyway, we're hearing from someone who really knows what's going on right now.
So
now you go.
Sounds good. Yeah. And by the way, we also, we do a lot of, unfortunately, we have to play a lot more defense than offense in Tallahassee, try to keep a lot of the bad stuff out. And been successful there overwhelmingly over the past few years. But yeah, so this has been an odd year because obviously most of the time, session ended in this year in March. And then usually by May, the bills are with the governor's reviewed them, signed off on them, and by the end of June. And so July 1st, we have ready to go out with what's called the 2021 legal update, going over 2020 legislative items. But bills, there's still a bill pending that was approved by the Congress that the governor hasn't even received yet. But those bills that he has received and signed off on, I will give you a brief overview. I'll give you a highlight of a few of them. This is certainly not meant to be all-encompassing. And once the state tells us what bills they want to see, we'll be holding courses that all board members and certainly managers for their CAM credits will be invited to. We'll go over all of these, but in no particular order. Emotional support animals. We finally got legislation passed on emotional support animals. And I will say this, I'll probably spend the most time talking about this one, and it won't be very long for the time constraints we have, but remember, everybody should remember, fair housing is federally legislated. So the state can only go so far in what the state can approve with regard to legislation. It can't conflict with what the federal HUD regulations are. And HUD came out at the end of January of this year with new HUD regulations, which were great that they offered us something. They didn't quite go as far as we had all hoped. But in that regard, we did get a new bill on emotional support animals that a couple of highlights. Number one, those certificates that people would submit that they get off the internet that said, hey, I got a support animal, those have now been, the statute says those are no good. Number two, a housing provider, associations can provide and this is something we've informed our clients for years, but you can, and it's recommended to have a uniform policy in place with certain forms, but an individual does not need to fill out your forms so long as they provide information that otherwise satisfies the requirement for it being a reasonable accommodation. So you cannot, number three, if an individual is giving you medical documentation in support of their request that is from an out-of-state provider, this is a good one, there has to be documentation from that out-of-state provider that they've seen the individual in person at least once.
Can they see them electronically, Mike?
Yeah, as long as they're seeing them, I believe they have to have an in-person connection. It can be electronically, but it can't just be where you go on a website, type in a few questions, and they spit you out a form letter. That has been determined to be no good, and that to me is the most productive piece of this, in my opinion, of this piece of legislation. It also codified things that we know of. You can't charge any fees to an individual who's requesting accommodation. Where you can charge for pets, you can't charge for support animals. You can't ask for documentation to say what is your medical issue.
Mike, this sounds just like the federal act. Is there anything different between what Florida adopted and the federal act? Because what you're describing to me.
Well, again, what's key here in the Florida, the points that, federal doesn't say anything about in-state provider. So that was very key, that it pointed out that if you're an out-of-state provider, that you need to have personal knowledge of the person, and it also needs to be in a field that I'm going to use as an example, and forgive me if it's people don't get offended, but a podiatrist shouldn't be saying that someone has mental health issues. That necessarily isn't in their field. Now, maybe it's a podiatrist who does have that background as well. I don't know, but by way of example only. So those are things that are important. That's a big one. The emotional support animal legislation, I think it does allow associations. It also criminalizes now. If someone claims that they have an emotional support animal and they don't need it, or if someone is on the medical side is saying this is an emotional support animal and it's not, it criminalizes that behavior the same way it criminalized it for service animals a couple of years ago. So there is at least that threat, if you will, that, hey, listen, let's make sure this is legitimate.
Mike, is the criminal on both sides? Is it both for the applicant and the medical provider? Or is that criminal penalty only on medical provider?
I believe it's on both, but I know for sure it's on the individual claim with the applicant.
Okay, and I know for sure it was on the medical, so between the two of us.
Yeah,
okay.
I believe it is, yeah. So that's important, and I think that's a good one. And again, I will point out, when it comes to issues about reasonable accommodations, generally and specifically emotional support animals, communicate with your experienced counsel on these areas. These are all fair housing issues. They're discrimination matters. They can become unnecessarily taxing on time and expense if you don't do things properly up front. So it's important.
I would say, just from a practical standpoint on the emotional support side, I got to tell you, for the communities we manage, it is one of the #1 friction points between residents and the board, for sure. It's emotional, no kidding, but it is really a friction point for someone who moved into a building or a community that had no pets, and all of a sudden they have a,
Right.
emotional support German Shepherd. People are, it's emotional.
Well, and listen, I can tell you those owners who feel that way, in my communications with many board members who volunteered to oversee this community thinking it's no pets, they're equally, if not more frustrated and with the situation, and they're coming to us and we're giving the advice, and it's like, hey, don't shoot the messenger.
Yeah,
But it is what it is.
Maybe a topic for another
couple of other items. Law enforcement vehicles. This is a bill that actually went to the governor during session, was immediately signed. It took effect months ago. And this is a bill that there were press reports out in Clearwater where a police officer in Clearwater had parked her vehicle, her cop car, if you will, in the neighborhood. And the association said, you can't have that. That's in violation of our covenants. And the legislature took immediate action. An association cannot deny a law enforcement officer from parking their vehicle in their assigned space or at their home. So that's clear. It does also define it to what a law enforcement vehicle is. It does not extend to fire rescue or EMT and it does not allow for equipment trailers or trucks. But if you have your law enforcement vehicle, your police car, that is permitted.
And it doesn't have to be a marked car with lights on the top either. It doesn't have to say Palm Beach County Sheriff's Office on the side. It could be a nondescript assigned police vehicle as well.
Yeah. Well, presumably, if it's nondescript, I don't know that anyone would complain as much.
Hard to say.
But yes,
I can't understand why anybody would complain in the first place. I have a sheriff who lives across the street from me. I was like, yeah, thank you.
I drive into my neighborhood. Right on my street, there's one of my neighbors. Their car is at the end of their driveway, and I love it.
Yeah, exactly.
The legislature passed another bill, Senate Bill 14. By the way, the law enforcement vehicle is Senate Bill 476 for anyone listening. FYI, the emotional support animal is Senate Bill 1184. The fireworks bill, Senate Bill 140. This allows for the use of fireworks on 3 designated holidays, which are New Year's Eve, New Year's Day, and the 4th of July. And it says that a homeowners association may only restrict the use of fireworks by way of the language in their covenants, which presumably means that you need the membership support to amend your documents if it's not already in there. The board cannot promulgate a rule that restricts. It has to be in your covenants. This bill does not apply to condominiums or cooperatives. It was applying to the HOAs only.
Not a good idea to light fireworks in a condominium.
No, definitely not. 2 other quick ones that I'll talk about. There was House Bill 255. This has to do with those of you online 55 and over communities. It removed the requirement that you register as a 55 and over community with the state every 2 years. So if you haven't been registering, don't worry about it. But I do want to be very clear. It does not remove your requirement to be doing your census every 2 years. You need to be, we're talking about, you have to be, at least 80% of the community has to have one permanent occupant, 55 and over, residing therein, and nobody under the age of 18. And you do need to do your census by way of affidavit or otherwise every 2 years to be able to document that you are remaining 55 and over. So this way you can, quote unquote, discriminate against families with children. The familial status wouldn't necessarily apply to you. Again, these are all fair housing and discrimination issues. Please communicate with Association Counsel to get clarification, get written opinions, get guidance to make sure you're well protected.
Craig, can I have 60 seconds on it?
Yeah, absolutely.
On that
sorry,
one?
Michael. I thought you were. No, I thought you were done.
No, I got one more. The last one I want to just point out, and again, it's not Jeff is going to add maybe a couple other items. The Protecting Tenants in Foreclosure Act was approved. And what this says essentially is in the case of any foreclosure on a federally related mortgage loan or on any dwelling or residential real property, that any immediate successor in interest, in other words, the person who takes title at foreclosure, assumes that title subject to the tenant being given at least 90 days notice for that they have to vacate. Now, the exclusion to the tenant can stay till the end of the lease or the 90 days, and there's specifics. But bottom line is this. In a foreclosure action, if you take title and there's a tenant under an approved lease who isn't the person who had the mortgage, if it's under the property, it's a bank foreclosure, isn't renting at a substantially reduced rate because maybe they were just a family member, they are given a minimum of 90 days notice before they have to vacate. So be aware of that. If it's someone who's buying the home as to own or occupy, there may be that may allow for a distinction. But do check with your counsel on that. But I just want to point out, this is new now, the Protecting Tenants in Foreclosure Act, which took effect July 1st.
Good stuff.
All right, and I'll give you just a couple. If you have any nuisance situations in your community, there are now statutorily required notices, 2 of them which need to be provided, and there's language that has to be used in the letter in the legislation. There are new excuses
Nuisances?
I don't know, Jeff. It's a nuisance provision.
I'm just giving a topical overview, guys. I'm not going into detail because we don't have the time right now. There are new excuses to avoid jury duty for students. So if your child is at university, they can let the courts know and not have to attend jury duty. There are new staging areas for electric charging stations all over the state roads, as well as providing for conservation easement rights for property owners where those stations may be provided. So I thought that was really interesting. There's changes in appellate procedures. Used to be, if you were unhappy in county court, you would then appeal to the circuit court, and then if you were unhappy, you would go to the appellate court. Now you go right from county court to the 4th, 5th, 1st, 2nd, 3rd District Court of Appeal. You no longer stop in the circuit court, which is fascinating. You no longer need to have witnesses for a commercial or residential lease. Also fascinating. I suppose if you're going to record that lease, you'll still need the witness signature, et cetera. So just interesting little tidbits to throw in there as well. Thanks, guys.
Oh, yeah, thanks, Jeff. The one thing I just want to say, that nuisance language, that's something that we need to flesh out a little bit more, because there's some very specific language in there that I don't know that it applies to nuisances in a community in general. So definitely we'll look further into that.
When we do a legislative session with Craig, then we'll bring
the
that
nuisances that it seems to relate to have to do with if you have houses of where people are using properties perhaps for brothels, things of that nature. It has some specific stuff in there. So I don't, like, if someone is playing really loud music, for example, I don't think that necessarily applies. I think you're following the governing documents, but it is new, and we need to kind of vet it a little bit more.
Michael, I want to go back for our 55 and better communities. With respect to the census, it is a requirement to have a form filled out and signed, an affidavit.
Every 2 years. Every 2 years you should be doing, 55 and over communities should be undertaking the census every 2 years, so that they have it on file. It's a requirement in order for you to qualify as a 55 and over. So if someone is to challenge that you're not a 55 and over, you'd want to be, because they're claiming you're discriminating against them because they're for familial status, families with children. You want to be able to support. You want in your governing documents that you have language that you're a 55 and over community. You want to make sure that at least 80% of all residences are occupied permanently by one person 55 and over, not owned by, but occupied by. And that second part you document by that census.
Interesting. And then I think, is it the same time every year for everybody? Is it due, if I remember?
No, the census is something you're doing when you should do it every 2 years. When you do it, it's not dictated by statute when you do it.
No, but I have to certify every 2 years, right?
That's what was removed.
Okay.
That's now been, you no longer need to send anything up to the state saying I'm a 55 and over. By the way, that certification, the last line in that said, if you don't do this, it doesn't affect your requirement. Right. So the fact they took it out, to me, makes sense. It's one of those things that actually makes sense. But I wanted to be clear, the fact that you don't have to certify with the state doesn't mean you don't have to internally keep your census records every 2 years.
Yeah, and the burden of proof is going to be on the association in a courtroom to prove they have it. So if you don't have it and you're running a 55 and older, go do it. Get it started.
Yes.
Excellent. Michael, that's a great summary. We got a bunch of questions on emotional support answers. No surprise there. A couple of quick ones. I think you told me that you can't dictate what form they submit on, number one, but there is paperwork that has to be submitted. Can boards go back to residents who have pleaded already that they have an emotional support animal and ask them to recertify? Or
my advice would be no. If you've already approved someone if someone has received approval for their ESA, you're not going back and saying, oh, wait a minute, we want better documentation.
Unless they want to pay out tens of thousands or hundreds of thousands of dollars.
Right. Right. I do not recommend that. I do think, though, that I think it's important that you put, and to the question on documentation, it's that we've always recommended, and HUD actually recommends, that you have a uniform policy and have a uniform application documentation in place, so that if someone says, oh, this is a support animal, great, would you mind filling this out so we can review and approve your accommodation? Again, everything positive. But if someone comes to you and says, here's letters from my medical provider, then don't hand them a document that says, have your medical doctor fill this out. I had that situation come up once where they complained, and what happened was the association was just giving them up their packet, and inside was this affidavit. They'd already gotten the medical documentation. So don't give them that.
And you can't make them sign an affidavit to begin with. So
right, you can't make them. You encourage it.
Right. And what we say, Craig, is here is a package that will assist the board. You're not required to fill it out, but it sure would be helpful if you did.
Right.
Well, I think there's enough data there maybe to expand on the whole ESA.
Right. Well, we offer a class. We offer our webinars on this. We do an hour on this alone, and we encourage everybody to join in the next one. I believe we'll have one in September, if not for sure in October.
And that leads me to the next question. There's no requirement for a board member to take.
Craig, come closer to the mic.
All right, can you hear me?
You got soft on us.
That's weird. Can you hear me now?
Nope.
Yeah.
But you got to, go ahead.
I do.
Is there a requirement for a board or director to take a legal update? I don't think there's a legal requirement, right? There's a practical, you should know.
Right.
But is there a legal requirement?
There is not.
No, none. No legal requirement. You don't have to recertify every year. We do suggest that board members do take a certification course every year, just because it includes innately a legal update. So you get the benefit of both.
Yeah, at least it touches upon it. But I'll go so far as to say we recommend it. I think as board members, you get your education. We offer tons of free education.
It's free.
And right now, as Jeff pointed out earlier, it's easy. You pop onto a webinar and you can get the information. Managers take the legal update to get their required CEU credits. Many board members have attended our legal updates over the years and gotten a lot of great information out of it. I think it's really helpful when you volunteer in this position to have that type of background information.
Excellent. Well, guys, we're nearing in on 1 o'clock, an hour, and I wanted to thank you again. Next webinar is 9:10. We do have Nicole Johnson from Hafer. We would ask the webinar participants to please complete the survey and let us know the things that you'd like us to touch on with Nicole, or anything else that we may be able to address in a future session. I want another reminder to do the census. I was pleading with everybody last go around, but please complete the census. Maybe encourage your community members to do the same, send out an e-blast, get with them. But I want to thank everybody again. Jeff and Michael, always a pleasure. Thank you for all of the information. I will see you guys in a couple of weeks. For our listeners, thank you very much for